Hi, my name is Brittany Partridge, and I'm an attorney at Butler Kahn Law Firm. I'm sure you've heard the term hearsay, but what is it and how is it used? So hearsay's definition is an out-of-court statement offered for the truth of the matter asserted, which basically means a statement that was said out of court that's now being used in court for the truth or to prove a fact. An example would be if a plaintiff was to testify. The driver said that he had drank 7 beers that day and that he knew he was going too fast, but he really wanted to get home to make it in time for dinner. Now, those are all statements by the at-fault driver or defendant in that case. And that statement by the plaintiff is technically hearsay. But you'd be surprised to find that a lot of hearsay statements come into evidence at trial. Now, hearsay is a very complex issue under the law. It takes a lot of time to understand and know in depth. There are multiple statutes that govern what hearsay comes in and what is considered hearsay, even when the definition, it may fit under the definition. In Georgia, the statute OCGA 248803 has a lot of exceptions to the hearsay rule, and I'm just going to go over a few of those today. The first exception I'm going to discuss is the present sense impression. And now this is the first exception under the statute OCGA 248803. And a present sense impression is basically statements by somebody who is currently visualizing a situation. So this example is oftentimes in 911 calls. If at trial we want to play a 911 call for the jury, there is somebody else on the line and they are talking to the 911 operator. Well, that witness is not going to be at trial because we can actually oftentimes play the 911 call without requiring that person to come to trial because what they're saying can sometimes be a hearsay exception. So if a witness comes up upon a car crash and they see the at-fault driver coming out of the car and they tell the 911 operator, "Ma'am, I see the driver, he's getting out of the car right now, he's stumbling out of the car actually, and he can barely stand up. He has no footing. He seems really woozy. And whoa, actually, I just saw a beer can roll out. And he threw up." Now, that statement may be hearsay, but under the present sense impression, since this witness is describing what they are seeing right now, that statement will likely come in at trial. Now, the second exception under the statute is the excited utterance. And an excited utterance is in response to an event, a traumatic, exciting, or just an impactful event that makes somebody utter something. Now, an example of this would be a driver and a passenger in a car. They get into a car wreck, and the passenger blurts out, "Oh my gosh, I knew I shouldn't have let you drive. I knew you drank way too much that day. I knew that you shouldn't have had that last drink. You've been drinking all day long, and I knew I should have driven." So that statement by the passenger, if it was heard by the other driver involved, that statement would be hearsay, but it would likely fall under the exception of excited utterance because that passenger is saying to the driver in response to this traumatic event, a car crash, that they knew they shouldn't have driven, they drank way too much, that the driver had no business being the one driving that day. Those statements are going to come in, or more than likely going to come in. A third exception to the hearsay rule is a then existing mental, emotional, or physical condition. We often see this with police officers and the reports of people on scene. So if a police officer gets on the stand and he testifies that the plaintiff told him that his leg is hurting, he feels like it's on fire, that statement that the plaintiff had made at the scene would be hearsay, but it would likely fall under this exception as a then existing physical condition because the plaintiff was telling the officer what he was currently feeling, and he felt like his leg was on fire and that his leg was hurting. So it would likely come in at trial. Now, this fourth exception, and the last one we're going to talk about today, is statements for purposes of medical diagnosis. Now, you often see this at trial if a doctor is testifying on the stand, and the doctor says, Yes, the plaintiff told me that his leg hurts constantly, that he has trouble sleeping, he can barely walk. Again, those statements might be excluded under the normal hearsay rules, but this is an exception because the plaintiff would have been telling the doctor this for purposes of medical diagnosis, so will more than likely come in at trial. Now, I say more than likely because it is up to the trial court judge as to whether or not a statement will come in. So while the attorney may believe that it's hearsay or it falls under an exception, it's ultimately going to be up to the court as to whether or not a statement will come in. Now, I hope you never have to worry about hearsay or using it at trial, but if you do, it's important that you hire attorneys who know the hearsay and Georgia Evidence Code so that you are properly represented and get the best representation possible. We hope that if you ever find yourself in need of a personal injury attorney, that you reach out to Butler Kahn. Thank you.